Good afternoon or evening, wherever you are, or whenever you see this. Maybe it'll be in the morning. I don't know. Hope everybody is well. Greetings to everybody. Hope everybody has a relaxing day and a great weekend. And I am going to summarize what happened in court this week, kind of give you my impressions. Obviously, as all of these sessions are, certainly not legal advice. But please like, subscribe, comment, share, and do whatever else you'd like with it. But this is just my opinion only. So take it for whatever it's worth and make your own decisions about anything, about all this stuff we're talking about. So what we're going to talk about today is the hearing that happened on Wednesday of this week in Las Vegas. I attended it in person, so I can talk about it in detail. I was also the subject of the hearing to some degree, so I will talk about it in detail in large part. Now I'm going to go through what happened, but I kind of have an optimistic view when we get to the end. So I'm going to preface that with what I tell you, and even though you might not get it until the end, that's kind of my ultimate view. So that's I'm laying out up front, so you know where I'm going with it. So before we start, of course, arguing with lawyers is like wrestling with pigs in mud. Before long, you discover they actually love it. Isn't that great? Who was the happiest to get that free U2 album on their iPhones? Anybody know? All the lawyers who work pro bono. What did the judge say to his dentist? Pull the tooth, the whole tooth, and nothing but the tooth. And last but not least, a trio, and no disrespect, by the way, intended to vultures. But here's a trio to end this little run here. What's the difference between lawyers and vultures? Vultures don't earn frequent flyer miles. What's the difference between lawyers and vultures? Vultures don't take their wingtips off at night. And last but not least, and kind of really what I'm doing here, what's the difference between lawyers and vultures? Vultures never tell jokes about how horrible they are. Interesting. Anyway, so let's just get to it. I wrote down a couple things, but let's get to it. So the hearing on Wednesday was a hearing. I think it was a status conference because we've now got to the point where we're basically every month we're having a status conference. And the primary issue, amongst other issues that we've addressed each status conference over the past at least 3 or 4, is the status of the audit. So part of that was the status conference. The other part was the compensation for the receiver. And there may have been something other, but it was, oh yeah, there was, but it was unopposed. It was, I think, just agreeing to an order that had been agreed to. So it didn't change anything, but there might have been a couple other matters. But the main matters were the receiver's compensation and the status of things. So for the receiver's compensation, the receiver's counsel spoke at length, and he, I don't know really why, the receiver's counsel at one point in time accused me, he said he didn't trust me because I did not have a monetary motive, which I was incredulous about, and I think I made a video about that. It seems like his approach has changed, so he spent a good amount of his argument basically referencing me in various ways, not very kindly, and basically said the issue being the receiver's compensation. Basically took the position that that's what was agreed upon, and the receiver's done a great job, and that this is not exact quote, by the way. I'm just telling you what kind of his position was. Basically, don't believe Hoffman, don't believe Candace, the other attorney for the group, and he went after kind of her position, but not quite as severe as me personally. But he went after both. And his basic position was there was a contract, receivers performed, he's entitled to his compensation. So that he made that out. And then he talked about the audit, and he said, maybe because an issue came up as to the audit, and it was Candace who made the argument. And I think I made it in my brief. I had two filings. I made two filings, one where I opposed the compensation, not that the total compensation, but asking for certain restrictions and limitations, and one on the audit where I said, what's going on. I laid out a bunch of circumstances justifying us to hear from the auditor. And in Candace's, the attorney who represents, I think about 40 plaintiffs, she kind of went through the audit history also, and she did in terms of the reports. That if you go through the reports at various times, there's reference, and again, these aren't exact language, but to the effect, there might be a report in November of 2024 where near the end and an audit will be done imminently or soon, and then we'll get to the next report and it says it again, or it says something else, and that's accomplished, but there's no audit. Anyway, she went through it, a series of that, and kind of implanted it into the judge. Not that the judge forced, and by the way, the judge is is very reasonable guy, I think. He lets everybody talk. He was I don't know him because I don't practice in Nevada. He was a attorney in Nevada before he became a judge, but he's very agreeable, and he generally lets people talk. But there's one disadvantage about towns like Las Vegas. So, and I lived in Las Vegas for about 6 months in 1988, a long time ago. And I've had experience in smaller towns. So in smaller towns, smaller courthouses, oftentimes there's fewer judges and fewer lawyers. And as a result, the fewer lawyers appear in front of the same judges over and over again. And in Vegas, they have what they call it, there's a certain number of business courts. So there might be 4 or 5. And Judge Williams, our judge, is one of the business court judges. I don't know if he's the senior judge, business court judge, whatever. That's 5 courtrooms. That means if you have business cases over, let's say, 10 or 15 years period, when you appear, you will be appearing oftentimes in front of the same judges. So they will get to know you. And as long as you don't piss them off too much, if you develop a relationship, I think it's beneficial. Not that anybody is not objective, whatever, just human nature. If you develop a relationship with someone, then you have more credibility. So if you make an argument, it might be more accepted. Doesn't mean it's accurate, true, whatever. It's just kind of the human nature. So Las Vegas to me is kind of that setup. It's not a huge legal community, and it's not a huge city in population. It's not saying that the lawyers aren't sophisticated and don't do a good job. It's certainly not the case that the judges don't do a good job, because again, like I said, I think Judge Williams is thoughtful. Seems like he reads most of the paperwork, and he certainly gives parties a time to argue. But human nature is that there's some relationship that exists that I think gives local attorneys an advantage, and that's everywhere. So if you go to a small town anywhere in the country and you go against an attorney from that town and you're an outsider, and let's say you have a jury, it's usually not helpful to be an out-of-towner. They usually will identify with the local attorney, and that there is some benefit to that. But anyway, that's kind of the backdrop. So Candace, getting back to that, the attorney for the plaintiff group. Now there's 2 plaintiff groups, just to be clear. So there's the original plaintiffs group, which I was a part of. It's about 200 plaintiffs, and that got the receivership going. And there is still a group of plaintiffs. I'm still a plaintiff. I'm not represented by that counsel. So I can't, whatever I say here, I'm not advising anybody in that group to do anything. But if you have questions, then you should reach out to your counsel. So again, there's two, in essence, two plaintiffs group, I'm calling it. One is the original plaintiffs group of about 200 plaintiffs. And I think Alex Calloway is the lead counsel on that. And if you have questions, don't, if you have legal questions and you're represented, don't send them to me or send them to me. Not that I wouldn't want to help you, but it's not appropriate. So send them to your counsel if you have questions. So there's one plaintiffs group of maybe 200 plaintiffs who all are shareholders. And then there's a second plaintiffs group, about 40 shareholders. And that group is, their counsel is Candace Caroline. And so she was at the hearing. So who appeared at the hearing? Present in person at the hearing were William Knoll, Dylan Siciliano. Those were the attorneys for the receiver. The receiver was present. I was present. There were a couple other people who were interested in the hearing that were present on Zoom, because they have that Zoom set up. Candace Caroline was there. And I don't remember off the top of my head anybody else being present. Maybe they were present, they didn't speak. The only ones who spoke were, at least to my recollection, were Dylan Siciliano, the receiver, Candace Caroline, and myself. So I kind of summarized what Ms. Caroline said. One was, maybe I didn't summarize. So one, she went to the audit and said, there's been a bunch of statements. So what's up, basically, and let's keep a short leash on it. And also suggested that if they're not able to get it done, shouldn't there be kind of some penalty? She didn't say it like this, but kind of this is the way I took it. If they don't complete the audit, then they shouldn't get all the money that they contracted for. That's the way I read her argument. And that deals with the audit. Now, in terms of the compensation, and this is kind of, we differ, but that's fine, because we have, she represents 40 shareholders, and I'm taking a pass at this from a different angle. But her position, at least the way I read it, was that there is a conflict, a potential conflict of interest between, or this is what she said, and this is how I interpret it, that there's a potential conflict of interest between the receiver and his interests in that he's a shareholder, and doing or not doing the deal with AIversity or whatever, that the interests of the receiver and shareholders might be at odds. It's kind of how I remember the argument. She didn't contest that the receiver was entitled to the compensation. She did, I think, in her brief, suggest that maybe in lieu of the shares that the receiver get monetary compensation, like a penny or 5 cents a share or whatever. I'm trying to think what else that she might have said about the compensation. So that in lieu of, and that this is only interim, so we'll have to revisit this at the end when there's a final compensation order. Trying to think anything else. Let me talk about myself, and then maybe while I'm talking about it, I'll think about anything else. But she kind of concentrated on the fact that there's a conflict, and there's at odds. And she cited a statute, a Nevada statute, that went to whether a receiver should be appointed, which became a contested issue. Or I think she cited it for the proposition that the receiver should be disqualified. I think Siciliano replied that it only applies to the appointment of the receiver, and since he was already appointed, the statute didn't apply. But the kind of the issue was there a conflict? That's what they raised. So my argument, after Siciliano focused a lot of his argument on me as opposed to the receiver, I spoke for a few minutes. I didn't deal with the personal, what I perceived as personal attacks, because judges don't like to, I could argue and say X, Y, and Z, but I've been in front of enough judges to know that they don't want to hear it. so I don't want to waste my argument. I limited my argument to whether, and this seems to be the law in Nevada, even though I'm not a Nevada lawyer, but this appears to be, at least my research and my understanding, that notwithstanding whatever the agreement, and this was the point, the bottom line point, there's an agreement in place. So does that agreement control over everything else? So the ruling in this particular case, as to this particular issue and this particular application, the judge went with the contract. My argument was that the compensation was not reasonable in total, that the receiver shouldn't end up being the largest shareholder, and there was no way for the shareholders to know what the final compensation would be. So even if they agreed to a percentage, they didn't agree to an unreasonable amount. And so the fact that the receiver might be entitled to some amount of compensation per the agreement is a separate issue from whether that amount is reasonable under the circumstances. That was basically my argument. The judge let me talk. I think his mind was made up already, which is not unusual for judges after they read papers and hear argument. And again, like I said, I mentioned, whatever I mentioned. In the end, the judge approved this particular compensation, which is some amount of cash, small amount of cash, and the shares. Now, let me get to the part I think is a good part. I think in a reply brief and in court, as I was hearing this, part of the reason they were justifying the shares and saying it was appropriate, etc., was the receiver's seeming representation or affirmation that he was in to GTII for the long haul and that he wasn't going to sell his shares. Now, I haven't seen anything in writing or a declaration or anything that where he's committed to that under penalty of perjury or anything. At least I haven't seen it. But in court, that was the seeming suggestion that he wasn't going to dump his shares right away and that he was here to ride the upside of GTII if it trades. And again, there's no assurance that it's going to trade, and certainly it's not going to be if the audit's completed. So this is what's not going to happen. It's not going to be the audit's completed on May 1 and it's going to trade on May 2. The audit's a necessity for it to trade, but it doesn't absolutely mean it's going to trade and doesn't mean when it's going to trade. So those two things. But in the way this deal is set up, the receiver only gets paid. He got paid some cash, but it's not for the amount of time he claims. I think he claimed he's put in 1,000 hours. So for the amount of money that he's been paid to date, because he's gotten some money because he gets 10% of all the money that's brought back. I think he's brought in, over $1 million. So I think he's gotten somewhere between 100 and 150,000 maybe out of that. And he's put in, he says, I think he said 1,000 hours. That's like $100 an hour. So that's certainly not excessive in my opinion. But he certainly represented, or it was suggested, it's on the record, that they had no intention of dumping the shares. And then beyond that, the issue would be that it was suggested by them, and I think Mr. Siciliano said, he prefaced his statement by saying he wasn't a securities lawyer. I think he said something like that. But that, and I think this is my opinion too, by the way, and I'm not a securities lawyer, but I think the receiver would be deemed an insider. And if he's and this is not an opinion, not a legal opinion, don't rely upon it. If you have counsel and you want to run this by them, then run it by them. But this is certainly not a legal opinion, certainly not a legal opinion about Nevada law or securities law. But some people believe, myself, maybe wrongly, that the receiver might be deemed an insider, and if he's deemed an insider, then there may be a lockup period of 180 days. What I don't know is when that lockup period starts. Is it from the time when he gets his shares, or is it from the time the stock starts to trade? I don't know which one of that applies, but it was certainly suggested in court, and I wasn't the only one who heard it, that the receiver is in for the long haul, and is not going to, because my concern, amongst many concerns, is that he dump his shares right away, and that would have a negative influence on every other shareholder if this thing ever trades again. So his representation about that kind of made me feel less concerned about that. But the other part was his compensation, because I don't think there's much more money to be returned to the coffers of GTII. So I don't think he's going to like pull back $20 million. And I don't know, but this is my impression. I don't think there's a bunch of money out there and they're going to pull back a bunch of money, and that the receiver is going to get compensated his 10% on that money. Maybe there's some, but I don't think it's a whole bunch of money. I think to the extent the receiver is going to get his compensation, he's going to have to sell his stock. And to the extent that and again, I don't know, so this is my thought process. And to the extent that he's going to sell his stock, the stock's going to have to be trading, because otherwise it's going to create, in my opinion, it creates a whole bunch of other issues. So it seems like that the receiver's interest with regard to his stock ownership, even though I personally think it's still unreasonable in amount. I'm not arguing about the end result. I'm arguing about just the reasonableness standard. But if the receiver is only making a boatload of money if he's able to sell the shares after it's traded, then to some degree, the interests of the shareholders and the receiver are aligned, because we would both need it to trade, to exit, and to get out of this position. So the fact that the receiver kind of indicated to me that he was not going to dump his shares, again, I don't think that was the express language, but that was the message that was communicated. And the fact that his compensation from this point in time really, I think, depends upon the stock being able to trade again, gave me comfort. Now, again, that doesn't mean the stock's going to trade again, just to say it again, but it gave me comfort. It seems like even if the intentions and motivations are not aligned, perhaps our stock interests in some way are aligned. Now, there are additional shares that I think that may be brought in. There may be further applications for compensation by the receiver, and if that happens, I would guess there'll be additional hearings, and maybe at some point in time, even though the judge found that it was reasonable on this occasion, if we get up to a certain level, perhaps it won't be reasonable. I don't know. I don't know what the judge's position will be. And again, this is not a position where I'm claiming the receiver did anything wrong or inappropriate. This is purely about compensation. And part of the argument that the court raised, and I think I corrected the court on this, was that this was agreed to by the plaintiffs, because the original arrangement was entered into by the plaintiffs and the receiver. But to be accurate, and I pointed this out to the court, plaintiffs did, in reality, the individual plaintiffs did not agree to this arrangement. It was counsel, and I'm not disparaging counsel, but I'm just stating the fact. It was counsel for the plaintiffs that entered into this agreement, and again, they, if I recall, they thought it was perhaps a great deal, but I don't know if they understood the potential consequences, because how could anybody, not knowing what we now know about the company? Now, talking So I hope I kind of line that up. So that's the stock side. And I feel better that our interests are aligned. And I feel from this point in time, the receiver will have a tough time getting compensated unless the stock can trade. And doesn't mean it's going to trade, but it means that we have some alignment. Okay, so that's the compensation side. The other side is the audit side. And it was pretty interesting. It was the first time I think I had heard the receiver. So the receiver spoke some during this hearing, and I think it was mostly about the audit side. So I think I mentioned that there were some briefs filed beforehand, issues raised about the status of the audit. The judge didn't seem to be particularly moved by the briefs that were filed challenging the audit. Then Candace Caroline made the argument as to what I said. And then Dylan Siciliano, and I think the receiver, I don't remember if it was the receiver alone or the attorney spoke, or first the attorney spoke and then the receiver. But he basically indicated that they apologize, that they were too optimistic with regard to the date of a completion of the audit. They kind of like fell on their own sword, whatever. I wasn't particularly impressed by that. But then the receiver he offered to show the judge in camera, which is perfectly permissible. In other words, in camera means in private, so outside to keep things confidential. But apparently, based upon the description by the receiver, and he indicated that it's imminent, being very imminent in terms of completion, which has been said multiple times. And then judge asked him, can you be more specific? I think not in a negative way, but asked him, and we're going back April 15th. But apparently there's 1,000 credit card transactions that are apparently. We've heard kind of similar stories before that this is the only remaining issue, but now it's been represented in court, so it kind of does have more power. But apparently there was 1,000 transactions, and apparently, without being specific, there is a lot of stuff that went on for 20 years. So it isn't just the last 2 years, but from what the receiver said, and he wasn't specific as to what this was, but there's been shenanigans going on for 20 years. And that was what he was willing to show the judge, or offered to show the judge. The judge said at this point in time he wasn't interested or didn't need to look at it. But I think this is the first time I can remember that the receiver offered anything concrete as evidence of the delay. Now, I would still prefer, and I don't know what that is, by the way, but if it's 20 years, I mean, the suggestion was there's 20 years of shenanigans. So is that civil liability? Is that there's a criminal investigation going on? Is that an IRS investigation on? It really looked kind of serious, to be honest, especially with the receiver asking to present the documents to the judge in private. It looked like something's going on. I'm just guessing, but from what he said, because of 20 years, and it sounded like from what the receiver said, it's been a real pain in the butt trying to reconstruct everything, even though this company had basically zero revenue, because there is so much sounded like. So this is my impression. It's not what he said, but he said there's so many manipulated transactions here, and transactions that don't look kosher, transactions that don't look appropriate, that it looks like this has been going on, for 20 years, and it's been like a long-term scam. And the auditors won't just sign off on an audit unless they're able to address all the questionable transactions. And the reason why they don't want to do that is because they don't want to be held liable if there's an error. And remember, in this particular case, the audit history has been terrible, right? We had Borgers, That was the original auditor. So, and by the way, Borges wasn't around for 20 years, so I don't know who the auditors were before, but it sounded like from what the receiver said, maybe there were prior problems with prior auditors. And I don't know if the receiver intends to go after prior auditors if they missed a bunch of suspicious transactions. I don't know, because that wasn't addressed. But Borgers was the auditor. The SEC shut him down because they were just making up stuff, literally. Then they chose Fortune. They, being former management, chose Fortune, which I think is in Orange County, California. Shortly after they chose Fortune, the receiver was appointed. The receiver elected to stay with Fortune, notwithstanding whatever they was referenced in the motions appointing the receiver about management. That's my criticism, by the way, again, is that if you conclude that management's not to be trusted, then why would you then take and rely upon the auditor that they used? But that's what they did. And 3 or 4 months after they relied upon the auditor that prior management had chosen, that they were, and where they knew prior management had problems, the receiver had to fire or discontinue use of Fortune because they weren't doing what they needed to do, or they weren't helping out, or something like that. So if the receiver had not, and again, this is just me Monday morning quarterbacking, but I think I brought this up at the time or shortly thereafter about the use of Fortune. Just thought it was a bad choice. I didn't think it made sense. And why is that? Why is that significant? It's significant because if they had gone, or perhaps it's significant. I don't know if it's significant or not, because perhaps the audit wouldn't have been completed. But what happened was, after Fortune, the receiver hired a new auditor. The new auditor, maybe they thought it was going to be completed faster or whatever, but the new auditor, some point in time during 2025, left on maternity leave. So perhaps if instead of wasting time at Fortune CPA, the receiver had elected to go directly with the third auditor, perhaps the maternity leave wouldn't have interfered with the completion of the audit. And that wasn't the only problem. Once, and again, I'm not attacking the auditor because she went on maternity leave. I'm just saying that probably that for various reasons, that may have been something that could have been handled differently if the receiver had rejected Fortune, for example, and which should have been done because that was the prior management selection. Again, I don't understand it. Maybe it was a money-saving effort, whatever. But that wasn't the only problem. Once the prior auditor left on maternity leave, the new auditors came from the same firm, and I still don't understand why, because it's not been explained, but apparently it is. They had to start over again, which I'm going to use the term delayed. It extended the time many months thereafter. So if in fact receiver had trusted the reason why he was appointed in the first place and not gone with Fortune, it's very possible the audit could be done. If the audit was done, maybe we'd be in a different place. Perhaps. Maybe the audit wouldn't be done because maybe when the auditor who went on maternity leave, maybe when she got to the end, maybe she would have been stuck on the same transactions that the subsequent auditors were stuck on. But I don't know. I don't know that for a fact. But I do know for a fact, and I think I said at the time, I just think that interim 4-month period was wasteful, and it may have been, impactful. And I'm not, it is what it is. There's nothing about it. But the point is that it wouldn't be unreasonable in light of all the proclamations that Candace Caroline mentioned, all these representations in the report that it's going to be, suggesting that the audit's going to be done soon, after this is done, etc. when you add that with how it was undertaken and managed, the fact that shareholders might be a little up in arms about the delay and require communication directly from the auditor saying all is great, we're finishing our work. Um, I don't think that's unreasonable for us to hear from the auditor. Again, not as to the conclusion, just to say we're still working on it. All is well. We expect to finish it. They don't even have to tell us when, but just to hear from them so they can basically confirm what has been suggested by the receiver in the reports and in court. Uh, it would make me feel more comfortable, certainly, if I heard from the auditor. And again, I don't need to know I've said this multiple times. I don't need to know the details. I just need to know that what we've been told is accurate. That's all. And if it's accurate and it's just being slow, then so be it. But if it's not accurate and it's something other than being slow, then I'd like to know that too. So the way it's set up from this point in time is we go back, I think, April 15th. So it's about 4 weeks, 3.5 weeks. And I based upon how the discussion occurred after the audit was discussed, I think if the audit is not completed in the near term, that the judges, and again, this is my speculation, but kind of reading the tea leaves, if the audit is not completed in near term being, I think if the audit's not completed within 60 days, I think the judge is going to get impatient. That was my impression. And I know it's a long time, but it is, it is what it is. I had asked for some kind of representation from the auditor. That's all. That obviously the judge is going to follow it, but was not interested, at least today, or the hearing on Wednesday, was not interested in getting something from the auditor, but he certainly was kind of interested in getting the audit completed. That he definitely expressed it. And I would say this is the most interest that the judge has expressed in the completion of the audit since we've started the receivership. So I listen, not exactly the way I of course would want to see the audit. I wanted it done, but it looks like we're making progress in it. It looked like it's serious, at least based upon how the receiver presented it without being clear about it. Certainly seems like the transactions at issue or the issues that remain are serious issues. Again, that was based upon the fact that he wanted to show the judge in private, because it's the first time that there's been any offer of proof like that. And, without being, because the judge, I think, tried to get a commitment from the receiver as to whether it was going to be done before the 15th of April. And I think the response was, again, imminently. And that's about as best they could do. And again, some of that may be outside the hands of the receiver. It may be solely in the hands of the current auditor. So I'm trying to think if there's, let me add a couple other things. Seems to me, and again, nobody's told me this, but just seems my impression is that the AI-versity deal, because it came up in the argument, to me, it sounds like that's a dead deal. I mean, or I don't know if it's dead, but it sounds like it's not moving forward. That's just the way it was suggested. But I also know, or I strongly believe, that other opportunities have been, or other opportunity, I don't know opportunities, but I will guess probably opportunities. But I know there have been other, or apparently have been other presentations made to the, or at least information provided to the receiver about other companies that might be interested in merging or doing some type of transaction with GTII. I don't know anything about the details. I don't know anything about the validity or the if it's a go, but apparently there is interest. Um, and if in fact there are any deals that go forward, hopefully they will benefit shareholders and GTII, because it would be nice if whatever comes into GTII brings value, whether that's in some product or engagement or whatever, or money brings cash to kind of to provide some type of funding for the company. But I don't know. Only thing I know is my impression was that the AI Versity deal sounds like it's going nowhere as of the current time. Of course, that could change, and that's just my impression. And I know, or my strong belief is there's other opportunities that have been presented to, or at least my strong impression is that's not the only opportunity presented to the receiver. Now, that doesn't mean there's going to be any deal done. I don't, it depends on the terms, depends upon what it is. But in the end, I don't, my opinion all along is that if there wasn't a deal done, that it's unlikely for the stock to ever be able to trade, regularly trade. And if it doesn't regularly trade, I don't see how any of the shareholders, including the large shareholders, in this case it might be the receiver, would be able to get out. So gives me some hope that, again, with it seems to me that at least as to the shares, whether I disagree with the amount or not, that the receiver's interest or his share interest and his desire to liquidate shares at some point may be aligned with us shareholders. And if that's the case, I think that a deal, some type of transaction would have to be undertaken, or else GTI is, I don't know what it is. It's just like a box. It's a really bad box, a very dark box, unless something's put in there. So that suggests to me that if in fact this is going to ever trade again, that there has to be something brought in. So that gives me hope also along those lines. So to summarize, hearing was on Wednesday. The receivers, two counsel from the receiver attended. The receiver, myself, and the attorney for other plaintiffs. Oh, Alex Callaway was, excuse me. So the other 200 plaintiffs, I think Alex Callaway was on Zoom, but he did not, other than his appearance, he did not participate in the oral argument. But he was there also. So there was a hearing, and the hearing was the compensation of the receiver was affirmed based upon the original agreement, giving the receiver 10% of the shares he brought back. And you can't argue that he's not brought back shares. The judge was impressed by the job that he did. There was arguments about his compensation. One of the arguments from one of the plaintiffs' group was as to the conflict of interest that might exist. My argument was the reasonableness of the fees. Then there was argument about the audit. One of the arguments was, there's been certain representations about completion. We have a hearing on April 15th following up on this. The receiver made a presentation suggesting that the audit's going to be done imminently, and the problem is a certain number of transactions and 20 years of apparent mistransactions. Next hearing is on the 14th, on the 15th of April. And in the interim, I will report anything that I hear. And that's it. So that brings you up to date. So the next thing I think I will be waiting for is, and I don't know if it will work out, but my impression is they're going to work out some kind of arrangement with all the big players, all former management, where my guess is that former management at least will return most, if not all, their shares, but I don't know that for a fact. But that's what I expect. I don't know how many more shares they can bring back, but there are some, because obviously they haven't settled with Reichman. The Reichmans are still outstanding. And I don't know what the status of negotiations are, or how many, or if there's been an agreement. But my impression is that there's been discussions and that perhaps they're close to agreement. I don't know, and I would have asked. I guess that would be something I would ask about. I don't know. So you have to weigh something here. You might decide to not settle something, but it might cost you so much in legal fees that it still wouldn't be beneficial. So my question is, because it was the first time I heard about it, basically during the receiverships, during this hearing, the receiver, told the court 20 years of, looks like 20 years of shenanigans. I think he used a stronger term than shenanigans, by the way, but 20 years of shenanigans. And he had never mentioned that before. So we were only thinking about the last couple years, 2-3 years. If they are aware of 20 years of shenanigans, then how are they going to justify settling with that defendant in court? As I just said, it might be an economic decision. Is they could say, we're not going to settle, but if it costs us $1 million in legal fees to get to the end, is that really beneficial? So there's still reason why you may not settle, but that's the first time where the issue of 20 years of transactions came out. And I don't know. I don't know if there's one person. I assume Reichman was there for 20 years. I assume, but I don't know. But whoever was there for that period of time probably has a problem, or at least seemingly by what the receiver said, may have a problem. But I don't know who that is. But that's kind of a different, that was a different disclosure, or at least in my mind, it was different than what had been disclosed before. And then does that create a problem in settling? Can you settle with somebody? So this is my question, my legal question. And if you're in law school, so your professor is going to ask you this question, and then he's going to have you stand up, and then he's going to ask you a bunch of other questions about it. So where you discover that perhaps somebody you're settling with has committed 20 years of fraud, and you didn't know about that beforehand, and it's going to cost a significant amount in legal fees to get the result if you don't negotiate a resolution, despite what you know, should you go ahead and litigate it, or should you settle it? It's a tough call, because from an ethical standpoint, if you think there's 20 years of shenanigans, obviously you shouldn't settle the case. Obviously not. But that's not, most law is business. And if just because a certain outcome may make you smile, it may not put $1 in your pocket. I think in the end, shareholders would be better off if they were able to get something out of this stock. So I don't know the answer. I'm just talking out loud. And again, it just occurred to me because it was the first time that the receiver was really clear about 20 years of transactions. So I don't know if there will be a resolution. I know that if in fact there is an agreement with the Reichmans, that there will be a court hearing in which that agreement will be decided. There'll be a court hearing where the court will decide if they approve the agreement. And perhaps some, I don't know, there may be parties that will object to it. I don't know, for that very reason. But here's the flip side of that, just so you can think about it. If you go on and you spend and again, this is the practicalities. If everything goes forward, and let's say you want blood and vengeance, and the receiver should have to go after, let's say, and again, I'm just speculating, the receiver had to go after Reichman, and maybe that would take a year, and you'd spend $1 million in legal fees, and the company goes bankrupt, Gtii. I don't think that's a great alternative either. So it'll be interesting if in fact, and it may be the case they don't settle, but my impression is they're going to end up with some type of resolution with them. So in light of this new disclosure about the 20 years of transactions, I don't know who it's with, but 20 years, it'll be interesting how the settlement is framed in light of that. So kind of that's that. So I think that summarizes that. Hope everybody's well. If I get any additional information, I will send it out to you. I'm sorry this thing's so long. Didn't mean for this to go so long. But that's the summary. So the compensation audit seems like we're moving on the audit. Seems like it will be done pretty soon. Seems like there's a lot of serious questionable transactions, and I will keep you apprised from there. So everybody be well, take care, have a great afternoon, a wonderful weekend, and see you soon. Okay?